Nerds, do I have a treat for you today? I have Professor Marin Sorensen from the esteemed Bowdoin College, who specializes in the U.S. Supreme Court. Now, we booked this this interview in advance, but it turns out there's something going on in the Supreme Court, so it's perfect timing. And thanks to our Bowdoin intern producer, Jordana, who made this interview happen. Welcome to the show, and hello, nerds, Marin.
Hello, nerds. Hello back. Yeah, really pleased to be here. And absolutely, it's as if it was planned that we would have an unprecedented leak just within this week.
It's
So I'm
crazy.
I'm here and I'm excited to talk. And so
Yeah,
yeah, let's do it.
it's so interesting talking to you because are you in Brunswick now? Or are you traveling or where?
So I live in Portland. So
Okay,
this is my home
yeah,
office in Portland, Maine.
much more hip area than Brunswick. Yeah, but it's funny because I remember when I applied to Bowdoin, one of the things that was going on when I was interviewing and applying was the Clarence Thomas confirmation hearings. And here we are now talking to a Bowdoin prof about different set of Supreme Court justices, including Clarence Thomas. But why don't we start with a little bit of a background about yourself so the audience knows who we're talking to?
Sure. Okay. So my name is Marin Sorensen. I'm a professor at Bowdoin College. I'm in the Gov department. I specialize in research in judicial behavior and Supreme Court decision making. So I'm not a lawyer.
Hmm.
I am a PhD. So my research focuses on those questions. How and why do justices and does the court behave the way that it does? What factors influence decision making, et cetera, et cetera. So that's my lens through which I've been viewing the events of the nomination confirmation process of recent con- uh, Justice, now we can call her Justice Ketanji Brown Jackson, and then also the very recent events that occurred on Monday with the leaked draft opinion of Dobbs versus Jackson Women's Health.
Yeah, there's a lot to talk about. And how did you first get interested in this area of all the things to get a PhD in? Like, what drew you to it?
I was an undergrad in a constitutional law course, which is now one of the courses that I am so privileged to teach. And I remember that I don't remember if it was actually an assignment or if it was mentioned by the professor that oral arguments. I did not know what oral arguments were. I had read case law for probably a semester at this point, but did not know what oral arguments were. And a con law class is not a judicial process class. They are very different modes of studying and thinking about the court and about law. And I don't remember if he actually had us listen to some in class or if he mentioned them and then I went and sought some out. And I was immediately interested, and my interest sort of surrounded the two cases of Griswold versus Connecticut, which is apt to be talked about today in relation to Roe versus Wade, and a predecessor, Poe versus Ullman, that challenged the same law but was dismissed. And so I was very interested in what I heard from the court in oral arguments. And that then sort of spawned a senior honors project that examined very closely those two cases and all of the elements of law that were raised at every stage of the decision-making process. And that was my entrance into this world.
Wow, super cool. That one class started now a career of looking into this type of stuff.
Yeah.
Before we go into the specifics, what do you think are some general things about how the Supreme Court works that maybe people need a reminder on, or sometimes people kind of there's some misunderstandings, just so that we can set some context before we dive into to the specifics.
Okay, great question. I'm going to go into a little bit more detail than I think maybe most people might know, because the court is
Well, you
and the
picked the right
judicial
podcast.
branch.
If you want to go into
Okay,
some more, this is the right place to do it.
perfect. The judicial branch is usually in high school government the least studied. And if the judicial branch is studied, it is normally studied through the lens of learning what would be considered landmark cases. You might
Hmm.
learn about Brown versus Board, Marbury versus Madison, but the actual process is not something that is usually covered in high school. Um, and then many people don't have the opportunity to take a judicial process class in college or just choose not to. So I'm going to give you the very short version. So as short as I can make it, and then if there are questions, I'm happy to answer those. So you got to have a law, and then you got to have somebody challenge a law. This often occurs in the context of a state case. States produce more law than the federal government does. They have a wider range of things for which they're responsible directly than the Congress does. So a state writes a law, and then you have a challenge to that law. The
Hmm.
challenge is heard either in a state district court or in a federal district court. It'd be heard in a federal district court if it's a state law, if there is a claim of unconstitutionality. So this is exactly what happened with Dobbs. So the law was written. There was a challenge to the law. That challenge was heard in the federal district court because there was a claim of unconstitutionality. The district court found on behalf of the abortion clinic. That then decision was appealed by the loser, who in that circumstance was the state. And then it was heard by the Fifth Circuit Court of Appeals. Court of Appeals is called an intermediate court often. And
Hmm.
once you get to the appeals court level, that's where most people have no concept of what happens in the court because it is not represented in TV or movies. So a district court, whether state or federal, is where a jury trial happens. And that is probably 98% of what is represented in TV or movies. Appellate court, there is not a jury. There is not new evidence presented. There are not witnesses. It is an attorney for each party that argues the legal questions and the legal factors in front of. At the circuit court level, it is a 3-judge panel. And then the Supreme Court is also an appellate court. So there, then you have the 2 attorneys arguing in front of the Supreme Court. Now, if you have lost at the circuit court level, you have to ask the court, the Supreme Court, to hear your case. You are not guaranteed review by the US Supreme Court. That is called filing a petition for a writ of certiorari. So you ask the court to please hear our case. The court then votes on certiorari. So
Mm.
it's usually the first opportunity that the court has to become involved. And it's often referred to as agenda setting or deciding to decide. And at the agenda setting stage, where the court is deciding whether or not to actually hear a lower court decision, the appeal itself, it only requires 4 votes for the court to take that case. It's called colloquially the rule of 4. That is a court norm to ensure that you do not have majority rule at every stage of the case.
Mm.
So if you have 4 justices who are willing to hear that case, now the court grants the petition for certiorari, and now the sort of clock starts. The petitioners have to file briefs. Then the respondents file briefs. At this brief filing stage, amicus groups, friend of the court groups, can also file briefs that attempt to inform the court maybe about other legal issues or other interests that are not necessarily represented in the briefs from the litigants themselves, because the briefs are limited. All briefs are limited in length.
Mm.
So a party couldn't just write a brief that's 300 pages long that is an exhaustive list of every single potential interest and perspective on that particular case. So amicus briefs can file, there are cases that get filed 100 amicus briefs. Now the court has all of these briefs.
Mm.
So we ostensibly would like the justices to at least have read the litigant briefs themselves that are filed by the attorneys who are representing the actual parties to the case. There is ample evidence that they also do read, if not all of the amicus briefs, at least a selection of them. They do mention them in oral arguments. After that, oral arguments are scheduled. Oral arguments are generally an hour in length in total, where 30 minutes are allotted to each side. And again, it's just the attorney that is representing that side. And he or she presents their case, but is mostly just pilloried by questions.
Mm-hmm.
The Supreme Court adopted a rule change to allow what they actually call a norm, or a general rule, that the attorney will get to make an opening statement that is uninterrupted, but that is not a rule that is always actually followed. So you can have an attorney get 30 seconds into his or her opening statement and have it interrupted. Okay, now, after oral arguments, they're usually scheduled Monday, Tuesday, Wednesday of the court's work week. Thursday, Friday is set aside for conference. So the court will sit, the court being just the 9 justices, in a closed room with no one else in there. No clerk, no secretary, no note taker, only the 9 justices. And they will engage in the preliminary vote for each case that they have now had the briefings and heard oral arguments on. At that point, they vote in order of seniority. And so that always starts with the Chief Justice, irregardless of how new the Chief Justice is. The Chief Justice is considered the sort of first among equals, the first among peers. And then at the end of that preliminary vote, the most senior justice in the winning coalition has the prerogative to assign the writing, or the choose the author of the majority opinion. So if the Chief Justice is in a 5-4 coalition, or the Chief Justice is in the 7-2 coalition, the Chief gets to assign that. If the Chief is not in that, then it goes to whoever has by years the most seniority. And we call that person the Senior Associate Justice, or the SAJ, in the winning coalition. That person then gets to select. You can, of course, self-assign. And Roberts has a history of self-assigning in fairly high-profile cases when he's going to be that sort of pivotal vote. And then we reach the stage where the Dobbs Leak opinions sort of occurred. And that is that whoever was chosen to be the majority opinion writer writes a first draft and circulates that first draft. The formal procedure for creating a majority opinion is that those preliminary votes at conference are not binding. So justices are free to write a dissent, write a concurrence, ask for an accommodation and a change to the draft that has been circulated, request specific language, request the removal of specific language or precedents or aspects of constitutional law. And draft opinions can reach into the double digits quite easily. It's not at all uncommon for that to happen. And there are anecdotal cases. This is certainly not something that happens often, where a justice is able to sort of strategically maneuver and steal the majority away by crafting a sort of middle ground that captures the individuals who were previously in the minority position and maybe picks off a justice who was a little bit on the fence, but that strategic justice might be able to offer enough policy space or accommodate enough of that justice's desires that they can now form a majority. And the way that you know you've got a majority is that you have 5 signatures, and that is it. So the place where the draft sits, and it is marked as a first draft that was circulated on February 10th, is that was Alito's opening try at keeping whatever majority he had at the time. Politico did report who they think the majority is, where Chief Justice Roberts is not in that. So we don't know any of the things that will have occurred after this draft was released.
I have so many questions. First of all, thank you for an amazing summary. That was brilliant. First question: the Chief Justice, who selects the Chief Justice? Do they all vote on who gets that role? It seems like an important role, but it was never clear to me how the Roberts got it versus anybody else.
The Chief Justice is just appointed. And it is appointed by the president
Mm-hmm.
in the same way that any associate justice is, and it goes through the same procedures. So Chief Justice Roberts became Chief Justice because William Rehnquist. Here's a great example. William Rehnquist was initially appointed as an associate justice, and then when Chief Justice Berger retired,
Mm-hmm.
Rehnquist had to go through the process again. You don't just sort of get a promotion because it is a separate seat that is separate in and of itself. And then when Chief Justice Rehnquist's health very rapidly declined, Roberts I don't recall if he had actually just been nominated as an associate or was about to be nominated as an
Mm-hmm.
associate. I think it was the former. I think he had just been nominated as an associate justice. And then George W. Bush put him in for the chief instead. So it is
Yeah.
just the normal process when the vacancy occurs that the chief justice is selected.
So if the chief justice, current chief justice steps down or is no longer able to perform that duty, then the president basically gets to pick. It's not like, oh, all of the justices got together and they said, we like, Roberts the most. Let's have him be the. So that's interesting.
Yep.
Um, Second question. So going back to hey, this all starts with a law that gets passed and then people challenge it. What was the law that gave, you know, rise to this whole decision that people challenge? Well, I don't even know. So much of the press was focused on the leak. It wasn't clear to me what was the original law that was being challenged and up through these courts.
So the original law was a 15-week ban. So
Okay.
it banned abortions that would occur after 15 weeks
Okay.
in a gestational pregnancy. That, at this exact moment, is unconstitutional because the present standard in Planned Parenthood versus Casey sets the line at which states can ban abortions at the point of fetal viability,
Mm-hmm.
which is medically somewhere around maybe 22 to 24 weeks. So
Got it.
15 weeks is undisputedly prior to that present line. And so that was the law that Mississippi, it's a Mississippi law, that was the law that Mississippi passed that was initially challenged.
Got it. And now, in order for us to get to this point where they're drafting a majority opinion, it sounds like this had to kind of work its way up all the way through the appeals courts or the circuit courts or whatever. Why was everybody so surprised? It's that then in that case we would have seen this coming and saying, "Hey, there's a abortion case going way up, and they're going to decide if they're going to take it or not." Were we all aware of this, or were kind of observers aware that this was moving its way up and likely to be taken on by the court? Because it felt
Gosh,
like it
that's
came
a
as a
whole
surprise.
host of unpacking questions.
Yeah.
So I'll try to unpack this as best I can. So the law was initially passed in 2018 and almost immediately challenged.
Mm-hmm.
It was not surprising that Mississippi passed this law because many states that are this is states are continually passing laws that try in some way, shape, or form to chip away at the
Mm-hmm.
current Planned Parenthood versus Casey standard. So that Mississippi passed this law was not especially surprising. It also was the Fifth Circuit Court of Appeals is a very conservative area. That's Louisiana, that's Texas, that's Mississippi.
Mm.
So that geographic area is very conservative, and they often produce opinions that are more conservative, for example, than what you get out of the Ninth Circuit. That's the California is
Mm-hmm.
the largest state there. So that wasn't surprising. I think so for court watchers and for I would say strong proponents of women's choice,
Mm-hmm.
this was not surprising. I would say for the public writ large, It maybe was because because these laws happen so often, and the court has taken so many different abortion cases, even since 73 and 92 when Casey happened, that I don't know. I suppose you could maybe say that it's somewhat akin to space travel. You know, when space travel first happened, everybody knew every single time that someone or something was leaving Earth's orbit. And I
Mhm,
think that that's quite similar to when you have a case that is the initial case that's decided in an area of case law, especially one that's as salient as this. And then as things so, and another example is after Brown versus Board, which of course, ordered desegregation of schools, public schools. There were many, many, many more desegregation cases that the public is not familiar with, um, probably for somewhat similar reasons. So, for people who follow this issue and for people who follow the court, this was not surprising at all. But for the public, it is something that has probably fallen out of media attention somewhat,
mhm.
just for factors of maybe familiarity.
Okay, so then when it got to this point of the draft leaking, I don't it sounds like this is kinda unprecedented or it doesn't happen often. What was the what was the motivation? Like, I presume that I mean, I suppose it could have just happened by accident, but it was it that the people who were in favor of of the minority opinion were trying to rally public, opposition, or what do you think was behind? Why was this leaked?
Sure. So this is entirely unprecedented, is where I want to start. So
Hmm.
there have in the past been sort of verbal leaks about
Mm-hmm.
things that have occurred. But to have an entire draft opinion leaked has not occurred, or at least that it became public. This is entirely unprecedented. The motivation of the leaker is really hard to discern because, in the same way that you just said, it could have been accidental.
Mm-hmm.
I don't think that it was accidental. You don't know. The motivations vary so much depending upon very specific circumstances of who it was. So certainly there could have been political motivations that are really linked to trying to force certain members of the court to behave a certain way, or attempting to create an issue that is maybe a little bit more heightened for midterm elections. It's just really hard to say. Um, because there are so many possibilities.
Mm-hmm.
Um, and so I have not engaged in a lot of speculation about kind of who were the motivation, because while I do think it was intentional, I don't know that I want to go out on a limb and say
Mm-hmm.
what the intention was. I'll make a few observations though. One is that, right, this is a first draft that would have been grabbed around mid February, and that whoever had this then sat on it.
Mm.
And I think that I think you could think about for reasons that this person would have sat on it and then decided to release it. But I also don't know that that gives us any particular insight to whether it was somebody who favored a conservative outcome or whether it was somebody who ultimately favors a liberal outcome in the case. Because one thing I will absolutely guarantee you is that this first draft is not the final draft.
Mm-hmm.
Chief Justice Roberts released a statement on Tuesday saying that this represents one draft. It's not, it doesn't carry the weight of law, etc. And that is true. So I have not engaged in a lot of speculation about who it might have been or what their motivations might have been. Um, so I'm sorry. I'm
No,
sorry.
that's I
Um,
I didn't. Yeah, I mean, it'd be amazing if you were like, I know exactly who leaked it.
oh,
um, So tell me a little bit about the draft. Like, what was your
mm.
read of it? Anything surprising come across?
Yes, a lot of things. So first of all, I was working on my computer. So this was posted by Politico around 8:30 Eastern time on Monday night. I was working on my computer and got a text from a colleague around 8:45 with the link to it. And the
Mm,
moment that I opened the draft, I knew it was real.
mm,
And part of the reason is for any interested viewers out there, there's an excellent online resource that you can just Google called the Supreme Court Opinion Writing Database. That includes a document archive that has memos circulated between the justices. This is mostly during the Burger Court, so sort of late 60s, early 70s. So memos circulated between the justices, and then there are photocopies of the first page of every single draft opinion.
mm-hmm,
So I have seen many, many, many of these in my research. And the moment I opened it, if any listeners or viewers are familiar with, the circulation stamp in the upper right hand corner,
mm,
along with the first draft that is there, and I think Politico or somebody highlighted it, are just hallmark things that you do not see on opinions that are released as even slip opinions to the public.
mm-hmm,
So and with the length of it and the footnoting of it, it all was just very clearly genuine.
mm,
Okay, so now to surprise, it is it is not surprising that it does directly overrule Roe and Casey. It says completely clearly that Roe and Casey were wrong when they were decided, and they need to be overruled, and the court is overruling them. That is not especially surprising. I think what was surprising to me about this is it's quite aggressive in its language.
mm,
It um, it is pretty harsh to the author. So Harry Blackman wrote Roe versus Wade. It is pretty harsh in its assessment of Roe versus Wade. The court that voted the majority in Roe versus Wade, and then also the majority in Planned Parenthood versus Casey. And then it pays almost no attention to the idea that this will impact women and
mm,
impact families who just want to be able to plan their family. And there are a few paragraphs in here that just sort of poo-poo those circumstances and say that, well, societal circumstances have certainly changed since 73 and since 92. No longer, is it considered so terrible for a woman who is not married to be pregnant. In many circumstances, I think the opinion uses the language, in many circumstances, law protects women in the workplace from discrimination based upon pregnancy. So it is sort of a general write-off of the concerns of women in quite aggressive terms. There are also some things that you've maybe read about that are fairly surprising. There is a sort of eugenics argument in here that
mm.
because at one point abortion was forcibly used, especially against people of color, that is a reason for outlawing abortion where that is a choice for the woman. There are citations to Ruth Bader Ginsburg. I think there's 3 citations to Ruth Bader Ginsburg, um, almost invoking her in a way to make it seem as if, see, she would agree with us,
Mm,
which is shocking. And then you also get the way that Alito in this defines what would count as a fundamental right definitely does call into question some other areas of case law. So I can hold that until if you had questions about that. But I know that that's something that's been circulating out there, and it's certainly at least present to me in my read of this.
So that last point, are you referring to this notion that, oh, well, this could be the beginning of a whole bunch of other kinds of decisions, and that it's not just about
Yeah,
abortion?
yeah, yeah,
Okay, so yeah, I've heard some people say like, oh, these liberals are making a mountain out of a molehill. This was just one thing. you see evidence that this pattern could repeat itself for other topics?
Yes. Can
Interesting.
I give a little history
Yeah,
on Roe
yeah,
itself?
yeah,
Sure.
definitely.
So, talking about Roe really requires us to talk about Griswold versus Connecticut. This is a 1965 case that challenged a Connecticut law that outlawed contraceptives. So, Connecticut had outlawed contraceptives.
Mm,
Um, this was challenged, and it was challenged first as a sort of an invasion of marital privacy. So a married couple engaged in intentionally testing the law by getting prescribed contraceptives and then being arrested for it. It was a intentional test of the case. Part of judicial process is that you have to be harmed to have standing to challenge a law. So
mhm,
you can't just say that's unconstitutional. You have to be arrested. That is one type of harm. A fine is another type of harm.
mhm,
So um, this was the way that the Connecticut law was challenged. It worked its way to the Supreme Court, and the Supreme Court said, "Yeah, we don't like the idea that states are trying to essentially legislate within the marital bedroom." The word privacy, however, does not appear in the Constitution. So we think that this law is beyond the scope of what states should be able to regulate. But how do we write a majority opinion that finds that right to marital privacy? So the answer is that the majority opinion talked about the Fourth Amendment's due process clause. And the due process clause basically says that states cannot deny you due process. Um, and they cannot deny you life, liberty, or property without due process of law.
mhm.
So the notion of Roe and the notion of Griswold is that we're going to read value into the word liberty.
Mm,
You cannot deny life, liberty, or property without due process of law. So we're going to read some meaning into that
right.
word liberty. That's what's often called substantive due process, substantive due process. That's the idea, is that we're reading
Mhm,
substance into that word. They also made reference to these general penumbras within the Constitution that suggest privacy. So they mentioned that the First Amendment right of association allows you to associate with whom you please. The Third Amendment that prohibits the federal government from forcing you to quarter soldiers suggests that you have some domain over your own house. The
mhm,
Fourth Amendment protects against unreasonable search and seizures. The Fifth Amendment protects you from self incrimination. If you sort of take these all holistically and you put them together, the Constitution suggests that there is some privacy, although they didn't use the term. And then they kind of founded that in this 14th Amendment due process. States may not deny due process with,
mm,
excuse me, life, liberty, property without due process of law.
mhm,
Roe sits on that idea.
mhm,
So Roe sits in this place where a woman's decision whether or not to bear children sits in that right of privacy. So although Casey, the 92, which is actually the precedent now, tried to think a little bit more broadly about abortion just being a liberty interest, we have other areas of case law that are fitting within this, and Abergefell v. Hodges, same-sex marriage is one of them.
mhm,
So although the Alito writes in the opinion that, you know, it's ridiculous to think that things like, so Lawrence v. Texas is also mentioned, that is the right to engage in sex in the privacy of your own bedroom. So you cannot attempt to regulate the sex act itself, is founded on this same liberty interest. So Alito does say it's ridiculous to think that we're talking about all of those other rights. We're
mm,
only talking about abortion. But the way that he defines what gets protection as a fundamental right under the due process clause
mhm,
um, is very limiting, because he wants it to be in this sort of long tradition. And I actually got the quote down somewhere. Central to ordered liberty is, I think, what it is. Um, So he is, even if you look at interracial marriage,
Mhm.
interracial marriage was banned by many states until Loving v. Virginia.
Mm.
Same-sex marriage was banned, or at least not codified as constitutional. So his reading of the way that we think of what a fundamental right is
Yeah.
that qualifies under that 14th Amendment portion is really limited to only things that have sort of been around
Yeah.
since the 14th Amendment was ratified. And that's a very limited number of things. And that really does call into question these other rights that scholars, reporters, et cetera, have been discussing.
Yeah, that's like a libertarian's nightmare, that unless everything is explicitly enumerated in the Constitution, it doesn't it's the opposite of the general principle of like, hey, just leave me alone. I'm going to make my own choices about whatever I want as long as I'm not harming like another, adult or sentient being. Um I see why, but what do you think was the motivation of then Alito to say, "Oh, but don't worry, this is just really for abortion." Why do you
Sure.
and what's his argument to say why shouldn't we be worried? Because why wouldn't you apply the same logic to, gay marriage?
So his motivation could be that he believes that, and that
Mhm.
he doesn't want to see those other areas of case law overturned. His motivation could also be maintaining a majority. So not to be insensitive, but Clarence Thomas is in this majority, and Clarence Thomas is married to a white woman,
Mm.
right? So, and Kavanaugh is potentially somebody who would want to be able to uphold a Bergefell, which is a same-sex marriage. So it is possible that he's doing this to attempt
Mm.
to maintain that majority. It is also possible that he genuinely believes it. Now, I can tell you what his reasoning is.
Mhm.
His reasoning is that in no other area of those pieces of case law is there another potential life at stake, and that abortion is different
Mhm.
because there is this potential life that is the sort of point of contention for anti-abortion groups.
Mm. Interesting. I mean, you could make arguments that some of those other liberties do affect other, I guess maybe not life or death. Is that his argument? That's life or death. I see.
His so he is quite careful in this
Mhm.
opinion not to take a position on when personhood begins,
Mhm.
because fetal personhood is, it is political, it is religious, and it would have a lot
Mhm.
of impacts in law.
Mhm.
So he is very careful not to take a position as to when fetal personhood is established.
Mhm.
Um, so he coins it potential life.
Oh,
That right.
okay.
So this is potential life, is what we're talking about,
Hmm.
because Planned Parenthood versus Casey sets that line of demarcation at the point of viability, where viability is medically defined as the ability of a fetus to survive outside the womb. So that is the
Mhm.
reason that it's set at viability, is at that
Mhm.
point, if a fetus is viable, it does make sense that, right, unless there are medical complications or severe birth defects, you wouldn't abort a viable
Mhm.
fetus. Prior to that point, that fetus is not able to survive without the mother, without the womb.
Mhm.
So that has been since 1992 the point at which, after the point of fetal viability, states can ban abortion so long as they make an exception to save the mother's life or health if a pregnancy could threaten that. Um, and this is where we come into conflict. So, Mississippi passes this law that says we're going to ban abortions after 15 weeks. That falls well before the point of fetal viability. And then we have opinion that says basically that Roe and Casey were wrong, and that this is a question that should be decided by states. And so states should be able to do what they want. States should be able to pass these laws in the interest of this potential life, protecting potential life.
We're going to get to some questions from the audience, Marin, but so if you're watching this live, go ahead and put them in the chat. I'll try and pick out a few. But before we get to that, one thing I'm curious about is I've been watching Supreme Court confirmation hearings for a while now, and I always recall when discussion of abortion comes up, justices are pretty consistent that they tend to say, hey, hey, that's the law of the land, that's settled law, it's precedent on precedent, surely when and in meetings with senators, they generally tell the senator, like, don't worry, like, we're not going there, kind of thing. What happened? Because now it seems like the majority has voted to say, yeah, this whole Roe v. Wade thing is complete rubbish. How did that? Do you think they knowingly misrepresented themselves, or were they just convinced by Alito's arguments, or how did that happen?
So Amy Coney Barrett would not say that Roe was a super precedent.
Mm-hmm.
It is completely uncontroversial to say that Roe is a precedent. It literally, by definition, is what it is.
Mm-hmm.
So a super precedent is this notion that it is so it is so settled. It is so settled that it is uncontroversial. And she gave as an example that sort of Brown v. Board is a super precedent. Mm-hmm. Although it was absolutely not settled at the time. It took around 10 years for widespread compliance to take place in the South, mm-hmm. and for meaningful integration efforts to occur. She would not say that Roe was a super precedent. As for Gorsuch specifically and Kavanaugh, and I know that, mm-hmm. Susan Collins here in Maine, it's been all over the news. Susan Collins said that, this is completely inconsistent with their, mm-hmm. statements to me, mm-hmm. in my interviews with them. So stare decisis is a Latin term to stand by what has been decided. Stare decisis is how the court thinks of precedent, and that we should have legal consistency, and that the court can't just, every few years be coming up with new legal standards. This majority opinion this draft opinion by Alito is like 68 pages long. And he spends a long time discussing the notion of stare decisis. And first of all, it is always recognized as something that is, quote, not an inexorable command. So it's not something that always has to be followed. And then secondly, he pulls on, in my opinion, really awful examples. He uses Brown versus Board overturning Plessy v. Ferguson separate but equal as an example, which is a little bit shocking, because mm-hmm. you there have an example of a sort of long-term fight for equality that's finally then recognized in Brown versus Board, mm-hmm. where here in overturning this, you have what would absolutely be the removal of an individual right. Mm-hmm. Yet he uses that as an example. So there is nothing that binds nominees or justices to what they have said. Mm-hmm. There is nothing that binds them to that. There is nothing that stands as an inexorable command that the court must uphold precedent. And so I don't know. I couldn't say if Gorsuch and Kavanaugh just flat out lied. If they have become convinced that Roe and Casey aren't workable. Alito spends a lot of time in this opinion discussing how unworkable of a standard Casey is, and the undue burden standard. I can't answer that. But Alito provides reasons, and mm-hmm. I think it's kind of up to you if you want to buy those reasons, but mm-hmm. they're in there.
Yeah. And I mean, I guess in those confirmation hearings, no one ever says, I would never overturn Roe. But it definitely, they give the impression that, I don't know, I get the impression watching those confirmation hearings that this is It would be a very unusual thing to overturn it, and I see no reason to do it or whatever. And here we are with the majority saying overturn it. And not just,
Yeah.
to your point, not just overturn it, but really kind of assault it in a way, saying like, this is terrible reasoning. This, like, of course we're going to overturn it. It wasn't this, nuanced, difficult decision. It was just like, this is not useful thinking, and we're going to overturn it completely.
I think that would
Um,
be a good
yeah,
categorization of the opinion. Yeah. A little
crazy.
background on, so I can give a little background on confirmation hearings.
Mm-hmm. Mm-hmm.
So there are really 2 points of demarcation. One is televised. So
Mm,
Senator O'Connor was the first candidate or nominee whose confirmation hearings were televised, and that marks a pretty big shift in the way that the senators behaved. If you
mm,
know anything about the advent of C-SPAN, when C-SPAN started, it marked a difference in the way that legislators behaved because
mm,
they were now on TV. Uh, and so you now have these hearings televised. Senators of the Judiciary Committee changed their behavior. And then the Bork failed nomination in '87 marks a sort of change in the way that nominees behaved in their
mm.
responsiveness to the questions that were asked.
Right.
Now, nominees are often very responsive to talking about their judicial philosophy. So, if we think to Amy Coney Barrett, she spent a lot of time talking about her originalism. John Roberts talked a lot about his sort of version of originalism. Ketanji Brown Jackson talked about what she called at the time her method.
Mm-hmm.
And I'm happy to talk about that if you have questions. But this is a discussion of the idea of the way that judges judge. They are far, far, far less forthcoming when they are asked questions about cases that they decided on lower courts, civil rights. They are extraordinarily unforthcoming in questions about civil rights. Amy Coney Barrett wouldn't even answer questions about, would it be illegal to engage in, I think it was Amy Klobuchar asked her about whether it would be illegal to engage in like voter intimidation.
Mm.
Um, she was asking her questions sort of around that, and Amy Coney Barrett said, I would need to know the exact facts of the circumstances of what was going on there. So
Mm.
issues that touch on sort of civil rights or precedents, they're not exactly forthcoming. And then we saw, I think an excellent demonstration of how politicized these hearings have become. We have Ted Cruz asking her if babies are racist.
Mm-hmm.
And we have Marsha Blackburn asking if she can define a woman. If
Mm-hmm.
she can't define a woman, then how can she decide on certain cases?
Mm.
Um, so we have, come a long way in the way that these proceedings happen and the way that they're digested by the public. But that any nominee would strongly go on the record stating that they would not overturn something is not something that ultimately ends up mattering for how they can cast a vote if
Yeah.
that issue actually comes before them.
All right. Let's hit some questions. Oh, one last one for me. Is there any chance that this decision actually, through the drafting process, someone's like, "Oh, I actually was with the majority, but now I'm not comfortable with this," or is
Yeah,
it
that's
like once they?
absolutely possible.
Interesting.
Nope. As I said, those preliminary votes are only preliminary, and
Mm-hmm.
until you sign on to the opinion, you are not. And that database that I mentioned, the Supreme Court opinion writing database, those memos in the document archive will show the phrase that they use is "Please join me." Dear so and
Mm.
so, I very much enjoyed the draft that you circulated on June 1st. Please join me. And that means please add my name to your opinion. I am signing on to your opinion. So
Oh, nice.
until that happens, and there are 5, there is not a majority opinion. To maybe go back to speculating just a touch, one of the
Mm-hmm.
speculations is that Roberts had maybe made some headway in moving one of the majority justices, maybe Kavanaugh, maybe Gorsuch, into his camp, which was probably going to be some sort of a middle ground opinion. And that it is speculated that this was then released to sort of forced the hand of that conservative justice to stay in the original majority block, so that they weren't painted as some sort of a flip-flopper.
Mm,
Speculation, but yeah, the document archive absolutely has examples of that thing occurring, where the majority opinion is assigned to a person and that person loses the majority because another justice is able to come in and engage in some strategic bargaining and get
mhm,
together a majority coalition that usually it's sitting somewhere in the middle, is the way that
mhm.
that ends up happening.
All right, let's get to some questions. BTS wants to know, is it possible to get more justices? 11.
Absolutely. Yeah. That is just Congress can do that. Now, it would be difficult because there's going to be a filibuster in the Senate for sure.
Mhm,
But it is the size of the federal judiciary, including the entire structure, the number of circuits that we have, the number of district court judges, Supreme Court justices, is all set by Congress. And so Congress could, just through an ordinary piece of legislation, expand the size of the Supreme Court.
interesting. Is there any limit? Like, then how does this like, what happens if, like, any party in power that doesn't feel like they have enough of their folks just keeps growing it?
Uh, so there is nothing that prohibits that from
Yeah,
occurring.
interesting.
So you will maybe have read about or learned about FDR's court packing plan when
Mm,
you've maybe heard of this. So
mhm,
he attempted to do the same thing because there were conservative justices who kept invalidating portions of his New Deal efforts.
mhm.
And that ended up being extraordinarily unpopular. And so he ended up not having to try to ram the legislation through because one of the justices sort of started voting with the more liberal bloc and allowing those pieces of legislation to stand. Um, so that was maybe a near miss in this eventuality, but the Supreme Court is not mentioned as a size. It's mentioned as having one chief justice. And it's given an original jurisdiction to hear things like disputes between states. And then Congress also gets to set the court's appellate jurisdiction. So Congress can remove whole classes of cases from the Supreme Court's appellate jurisdiction if it wanted to.
Hmm,
So the Constitution, and I'm just holding my little pocket Constitution here, gives Congress fairly a fairly good amount of power in that sort of checks and balances over what the court could do. Now, the court has generally been quite impervious to what we call court curbing legislation because it has historically been the sort of most trusted branch of the three
mhm.
branches of government. But there is nothing procedurally that prevents it from happening. It's a question of
Got it.
politics.
Another reason to participate and make sure your congressional representatives align with what you believe are your interests. Vaughn has a question. What do you think the impact of Roe is on the poor if it were reversed? Um, yeah, any thoughts on that?
Sure. So there is quite a bit of sociological data in both, especially Roe, but also some in Casey, in the majority opinion, about this exact economic question. And it is widely reported, lots of different research on this, that yes, the abortion is something that is often used by women of lower socioeconomic status or the poor, here as Vaughn phrases it, and that abortion, or excuse me, forced pregnancy or unwanted pregnancy does does impact women with less economic means more, right? A baby costs what a baby costs, and
Mhm.
so if you have less money, right, formula costs what it costs, diapers cost what they cost. So I absolutely sit in the camp of that being disproportionate impact for sort of women of color, for women who are of lower socioeconomic status. Um, because sure, okay, New York and California, more liberal states, may continue to be able to perform abortions, but you've got to get yourself there.
Mm,
And
mhm.
so while, middle class or more affluent families would be able to afford flying you to wherever in the hotel stay that it would require, it is a disproportionate impact for women that don't have those financial means. The majority opinion handles that by saying, well, just give your baby up for adoption. It's honestly
Mhm.
in there. Is that states have all 50 states have some sort of a safe haven law that allows women without penalty to drop their baby off at a fire station, is normally what it is, or to give up their baby for adoption. Um, I don't think that is a societal, uh, I don't think that that is a wholesale and societal remedy to this. Um, but that is the way that the majority opinion addresses it.
Mm. Next question. Will the leaker ever be caught?
I don't know. I don't know that I would be able to say. On Tuesday, when Chief Justice Roberts uh, he released a press statement validating that this leaked draft is in fact real. He also said that he has directed the marshal of the court to investigate the leak.
Mhm.
I don't know how many resources the court would want to put towards this. I really couldn't say. I really don't know. Again, I make an observation that this looks like someone has scanned a physical copy of it.
Mhm.
I don't know what the technology is at the court. If they use the scanners there, would a record of it be available? I honestly, I don't know, and so I wouldn't want to speculate on that.
Yeah, that's interesting, and you really can't involve the FBI or anything that would have a lot of resources because now you're kind of mixing the branches of government, I suppose. Like the
Well, and
Supreme.
so far, there's no accusations that this is a criminal investigation.
Mm,
So,
right.
what is this confidential? Yes. Is it classified? No.
Mm. Marin, what an interesting conversation and timely one. I have a feeling people will really enjoy learning all of the nuance that you shared with us in this podcast. So thank you so much for coming on. Is there anything else that you wanted to mention before we wrap up? It's been amazing.
I mean, set yourself a news alert. The majority, the true majority, will probably be handed down the final week of June.
Hmm.
That's when most of the more controversial and high profile opinions are handed down. So we will all see, because I don't suspect there will be another leak before that point.
Mm. Well, let's get you back on in the future. I'm sure there's going to
Hmm.
be more drama and monumental stuff going on, given the area that you cover. And thank you again for taking a little bit of your weekend to spend time with the nerds audience.
Yeah, of course. It was great. Thank you so much for having me.
With that, we'll say goodbye, nerds.
Yeah, goodbye, nerds.
Thanks, Marin. See you.
Bye.
Bye. All right. Wow. Thanks, Jordana, for getting Marin to come on the show, and thanks to fun to feature all these Bowdoin College professors. If you have a college, a high school student thinking of a small liberal arts college in New England with a very distinguished history and amazing food and clearly incredible professors, check it out. Before we wrap up, I do want to, you know what we're going to do? We're going to give some shout outs to both um, members of this channel. So if you're on YouTube and you want to click that join link, you can support this content and the channel so that we can keep producing hopefully useful stuff for you. And then we're also going to highlight some of the top candidates of the people who are trending, running for office that might be worth a look. So let me pull up all of that info so that we can give some recognition. So let's start with our channel members on YouTube, and we're going to start with the highest level, and then we'll work our way down. So at the highest level is our senior vice president, Soldier One, who has been a supporter of this channel for over 2 years now. So thank you, Soldier One, for everything you do. It's awesome. Um, Also, thank you to StreamYard, who is providing us with the live streaming service for free, and they usually charge people. So thank you, StreamYard, and thank you, Soldier One. At the VP level, we have Kristen Slevin, Bike, and Stephen Jones. Kristen has been a member for 28 months. Jeez, amazing. Thank you, Kristen. At the hardcore nerd level, we have Gene, David, DK, Jekkalego, Kirsch, Mr. History, Byron, Mona, Susan, Vaughn, Yang, Tony, Robert, Dean, Snapnerd, Galessa, Jay Perrin, AH, Jay Bryan, Dana, Jason, Parth, and Daniel. Daniel's the one that got us the StreamYard support. And then verified nerds, entry level, $1.99 a month. If you're listening to this and you made it all the way to the end, consider joining. Like Lisa, Albert, Brandon, Peter, Arez, Your Maman, Sophia, Mike, Jadwiga, Doris, Emerald, Ben, Rasta James, Emma, Hui, Elizabeth, Ira, Shoni, Jameson, Dr. William, Karen, Monica, Arden, Semery, Mai, David, Brittany, Alexandra, Juana, Warren, Lucky, and Kevin. All right. So those are the people that make this channel possible. I also want to call out some interesting candidates who are running for office, and it is a very interesting time. So let's check out who is currently trending. And I'm probably going to need to update these because I'm guessing there's been some primaries. Hopefully, some of these folks made it through. Right now on ofthepeople.us, which you can go and vote using approval voting. You just click on the person's name and say approve, go to candidates, and you say Control F, and you can search for anybody, and then approve them. So who is getting the most recent approval votes? Josh Whale, Stephen Houlihan, Dan Whitfield, Rose Yee, and Jermaine Johnson, Catherine Fleming Bruce, Joaquin Vasquez, Luis Rivera, John Fetterman, Alan Ellison. And, it's interesting. You see, we have these tags. Since we were just talking about Roe, pro-choice candidates that you may want to check out, Colin Hardin and Lauren Hubbard. So check them out because they explicitly added pro-choice to their profile tags. And if you know someone running for office, they can list themselves on Of the People. It's an open platform. And you can get discovered, and you can provide a little more information about what you believe in. You can tag some policies, and we'll highlight some recent tweets from you. And then we're working on adding a new feature soon, which will be a Ask Me Anything feature. So you can ask the candidates questions, and they can answer them, and it'll be part of their record. So with that, hope you have a great weekend. If you could do me a solid, since 10 of you are still watching right now, if you haven't liked and shared, that's another way you can help out the channel. So have a great weekend. Goodbye, nerds.